Welcome everyone to today's session. So glad that you're here. We are going to get started and I'll just let folks in as they come in. So thank you so much for being here. My name is Heather Johnson and I am the Director of Volunteer Halton, and I am pleased to welcome you to today's session on the Ontario Not-for-Profit Corporations Act transition process. And I was going to go through a couple of quick things before we get started, and then we will turn it over to our presenter today, Benjamin Miller. All right, so technology and I got to get along today. Here we go. So just want to go quickly through our agenda. So we will have a land acknowledgement. I want to talk to you a little bit about community development Halton and volunteer Halton. There's a lot of folks here that may not know about us. Tell you a little bit about some upcoming education sessions, a couple of gentle reminders, and then we will introduce Benjamin Miller and get started with our presentation. So I'd like to begin with the land acknowledgement. So we acknowledge that Halton is rich in the history and modern traditions of Indigenous people. Halton is on the traditional lands of the Mississaugas of the Credit, part of the Anishinaabe Nation that extends from the Niagara Peninsula across Hamilton, Halton, and Toronto to the Rouge River Valley. And we thank the Mississaugas of the Credit First Nations for sharing their traditional territory with us. We also recognize the enduring presence of Indigenous people on this land. And I do encourage everyone to take some time to learn more about Canada's history with our Indigenous peoples. I know for myself, my education continues. This was not something that was taught to me in school. So I am very grateful for our Indigenous people who are willing to share their stories. For far too long, their stories were not taken seriously, and I'm glad that we are beginning to listen and to learn. So thank you for that. Let me tell you a little bit about Community Development Halton and Volunteer Halton. So for those who aren't familiar, Community Development Halton, we are an organization supporting Halton Region with 3 pillars of service. We have, and through research and community development, planning and promoting volunteerism, our goal is to help improve the quality of life for all residents of Halton Region. And we do that through 3 main pillars of service. So we have a social planning and research team, and this is an organization that really takes a look at activities within the community, supporting community organizations, using data to help affect change for positive change in our community. We also have our age-friendly initiatives. And as we know, if we create communities that take our older adults into consideration, all of us will benefit from that. And then, of course, there's also Volunteer Halton, and I'm going to tell you a little bit more about that in a moment. You can learn more about all of our programs at www.cdhalton.ca. And I do know that a few of our board directors from CD Halton, Community Development Halton, have joined us today, so welcome. We would be very happy to answer any questions or support anyone who's interested in using any of our services. Volunteer Halton, we are the volunteer center for Halton Region. Our mission is to build community through volunteerism. And we envision a region where volunteerism is accessible, inclusive, and valued, and it contributes to the well-being and engagement in our communities. So we do a number of different things. For example, our CDH Educates workshop series, of which this presentation is part. We do focus conversations, opportunities for communities of practice to come together and talk about and share information on topics of mutual concern. Volunteer recruitment and referrals. If your organization engages volunteers, we could help you reach out to people in the community who are looking for opportunities to serve. We also advocate for the volunteer profession, working with various levels of government and various other organizations in the province to promote volunteerism from young people up to our older adults. And we're also a catalyst for volunteerism and civic engagement in Halton Region. I'm very delighted that you've come and joined us today. Who am I? So I'm the Director of Volunteer Halton, and I have 20+ years of experience as a volunteer engagement professional. I joined this organization in 2021, May of 2021. And my role is to work closely with organizations and agencies who engage volunteers. And I also provide consultation and support to volunteer seekers. So I am here to support all of you as you're doing your great work in the community and engaging volunteers in doing that. Just want to tell you about some upcoming sessions that will be happening that may be of interest to you. We do have a volunteer engagement workshop series coming up. We're going to be talking about legislation and policy in March. Staff buy-in, how do you get staff to get on side with having volunteers in their program? And that's going to be in April. April is also when we celebrate National Volunteer Week, and we'll be having our Volunteer Halton Awards during that time as well. In May, we're going to talk about the 10 steps of screening, proper ways to screen your volunteers. And in June, we're going to be having a session on volunteer program evaluations. Please watch your emails, please watch our websites and our social media channels for all the registration information on those upcoming sessions. So just a couple of gentle reminders. So please keep your microphones muted during the presentation. It is being recorded. The recording will be made available. Questions are welcome. Type those questions into the chat box. I'm going to be monitoring the chat box, and there will be a few set times during the presentation where questions will be taken from you, the participants. This is a safe space and it is a brave space. This is we want people to feel comfortable to share. We want people to feel that their situations will be taken seriously, and we want a respectful environment as we all learn together. As I mentioned, the recording of today's session will be sent to all registrants, and there will also be an evaluation that will be sent out following this particular session. So now I'm delighted to introduce our speaker to you today. We are welcoming Benjamin Miller, and Benjamin is a staff lawyer on the Not-for-Profit Law Ontario project of the Community Legal Association of Ontario, also known as CLEO. Where he focuses on nonprofit and charity law and policy. Over the past 4 years at CLEO, Benjamin has answered hundreds of non-for-profit law questions and developed an online interactive bylaw builder for the Ontario Not-for-Profit Corporations Act and its transition project. Benjamin also works at the Ontario Not-for-Profit Network, also known as ONN, and has worked at the Canada Revenue Agency in the past. I am delighted to welcome Benjamin to today's session. I'm going to stop sharing my screen so he can start. And welcome, Benjamin.
Thank you so much for having me. I am absolutely delighted to be here, and I can tell it's a really good crowd already because of all of the great questions that were asked in the pre-session surveys. So I'm hoping I get a ton of value from these sessions and hearing all the questions people ask. So I'm hoping you'll keep the momentum going, and you'll also find value in the session. So as Heather mentioned, I'm here today to talk to you about the Ontario Not-for-Profit Corporations Act, and don't worry if you don't know what that is, I'll talk about that too. There'll be three main sections to my presentation. I'll discuss some of the new elements in the ONCA, the kind of big ticket items, but don't worry, it's not too different from the previous act, the Ontario Corporations Act. Then I'll discuss what steps nonprofits need to take to transition. So that's the step-by-step, where do you begin, what do you do, when do you get a lawyer involved, etc., or if you even need a lawyer. And then number three, I'll discuss how CLEO can help, or I'll discuss our free resources to address some of the needs that may come up. Now, my project is part of Community Legal Education Ontario, which is a legal aid clinic part of Ontario's legal aid system. As opposed to other legal clinics that provide one-on-one services, advice, and representation, we don't do the one-on-one advice and representation. Instead, we create legal information and education like this session on a wide variety of topics that might be of interest to you or the clients you serve. For example, housing law, employment law, family law, criminal law, discrimination law, you name it. So I would encourage everybody to check out some of our other websites, such as stepstojustice.ca. Now, I am a lawyer, and you know how lawyers are. We enjoy our disclaimers. I have not one, but 4 disclaimers for you today. The list grew as I delivered more of these presentations. Number 1, the first disclaimer. This presentation is general legal information. It isn't legal advice tailored to your specific situation. I don't know all the facts of your situation, so I couldn't properly advise. So I'm not going to be giving specific answers to your specific situation, only kind of what's generally the case. Number 2, this is a high-level overview of the ONCA. So it isn't a comprehensive discussion of the Ontario Not-for-Profit Corporations Act. If you'd like more detail, you can go to our website, which I'll share the link at the end of the presentation, nonprofitlaw.cleo.on.ca. And I should also note, we're discussing the ONCA. There will be a few places where I'll discuss charity law. I may discuss the Charities Accounting Act at the end in response to a question that was asked. But when I'm talking about those other acts, I'll specifically flag it. So the default is I'm not considering the other acts that may apply to you as a charity or if you're a regulated organization under some other act. The third disclaimer is that this presentation is about law and not best practices. Just because something is legal doesn't make it a good idea. My job here today is to highlight the new options available to you under ONCA, but just because a new option is available doesn't mean you need to take advantage of it. The fourth disclaimer is that this presentation is about law and not about funder expectations, particularly when we come to the section on financial review. You'll see there is a new flexibility available under the ONCA. That wasn't available previously under Ontario Corporations Act, where organizations may not need to get an audit. However, your funders may still expect you to get an audit. So that's a separate conversation to have with your funders. I'm just talking about the ONCA here today. So you've already heard one land acknowledgement. I'm not in Halton, so I'd also like to acknowledge where I'm coming to you from on behalf of myself and also on behalf of CLEO. So I'm in downtown Toronto, the traditional territories of the Mississaugas of the Credit, as you heard, the Haudenosaunee, and the Huron-Wendat. And in addition to acknowledging where I am, I also want to acknowledge my place in broader systems of colonization and my privilege in those systems. And what that means for us today, when we talk about corporate law, is acknowledging the fact that corporations for hundreds of years, and they continue to be, used as tools to evade responsibilities, legal responsibility for harms done as part of colonization. My hope is that you take this information here today, not in order to evade responsibility, but to make more accountable organizations that are more responsive to your communities. But unfortunately, both are possible with the law. Now, CLEO staff, including myself, are in an ongoing learning process about the nature of anti-Indigenous racism in Canada, its systemic nature, as well as other forms of racism. And we're actively trying to sensitize our legal information to the experiences of Indigenous people and to better reflect the wisdoms of Indigenous people and the treaties. So with that in mind, before we jump into the specifics of the ONCA, I want to take a step back and reflect on the meaning of legal compliance in general. What does it mean to comply with the ONCA as well as any other law, and the meaning of good governance. And the way I'd like to do this is by contrasting two sets of treaties that apply to the land where I am. On the one hand, we have the dish with one spoon treaties, a series of treaties dating back hundreds of years between the Haudenosaunee and the Anishinaabe peoples, embodied in wampum belts, such as is pictured on the left there. So these are intricately woven belts of shells. And the way they work in practice is that at important meetings between the signing parties, a messenger is sent, a special messenger, and the belt speaks through the messenger, reiterating the terms of the relationship. And so naturally, as time goes on, this relationship grows, and so too with the terms being articulated at these important meetings. Contrast that with Treaty 13, the so-called Toronto Purchase, the first attempt at which was made in 1787. Now, by 1805, the Lieutenant Governor of Ontario was so disturbed by its questionable legality. This is a treaty with the Mississaugas of the Credit. He was so disturbed by its questionable legality that he asked his staff to go looking for it. Now, note already the red flag that he didn't know where it was. They didn't know where it was. So they went looking for a copy. They found one copy, I think literally in a shed somewhere, and it was a blank deed with signatures from other pages attached. Okay, so what does any of this have to do with you? Very often, I come across nonprofits whose governance much more closely reflects Treaty 13 than it does the dish with one spoon. What I want to emphasize here today is that legal compliance is not something that you write down on a piece of paper, file away, and then pull it out 20 years later when somebody gets anxious about something, right? It's iterative. It's something that is brought up at important meetings. It's fundamentally about the underlying relationships. So the takeaway here today, if you take nothing else away here, is that this presentation is about getting your documents up to date, your articles, your bylaws, and we'll talk about what that means soon. But that's just the beginning of complying with ONCA. The actual compliance process is how do you take what you did to your governing rules and how do you manifest that in practice on a kind of day-to-day basis. So some key terms to make sure everybody's on the same page. You received a document. Don't worry if you didn't read it, but if you did, that's great. It contains some of these key terms. So ONCA, what is ONCA? It's Ontario's Not-for-Profit Corporations Act, and it's the legislation that most nonprofits incorporated under provincial law will need to follow to govern their governing rules, things like how does their board work, how do their members meeting work, what documents do they need to keep, their corporate records, etc. So it governs that type of thing. It replaces Ontario Corporations Act. It does not apply to federally incorporated organizations. So some of you asked the question in the pre-session survey, does it apply to me? Well, if you're federally incorporated, it doesn't apply to you. If you're a business corporation that happens to run on a nonprofit basis, it doesn't apply to you. If you're a co-op, it doesn't apply to you. So I'll just get that right out of the way so you can leave the session if you don't want to say and save yourself the remaining hour. Some other key terms, governing documents. When I talk about governing documents, what am I talking about? Number one, I'm talking about your letters patent. Now, this is one of the changes under the ONCA. It's now referred to as articles or articles of incorporation. I'll use the term articles. It's the same document. Letters patent, articles, they're the same thing. It's the document that the government gave you when you first got incorporated, and it includes important information like the purposes of your organization, the address, the official headquarters, and other special rules, such as if you put limits on who you could sell your property to, or who gets your property if you ever dissolve, and we'll talk more about what that means later. We'll talk a lot about articles in this session. Secondly, bylaws. You may call it constitution, you may call it your governing rules. There are lots of names for it. It's not the name that matters, it's what's inside. This is the document that you developed, so the government doesn't send it to you, you developed, and it contains your governing rules, like who is a member, when do you have members in board meetings, etc. So it's a lot of that kind of the operational side of governance. We'll talk a lot about bylaws. And thirdly, policies. We won't talk a lot about policies in this session because the ONCA doesn't really directly address them. I only bring it up here so that you know that we're not talking about policies when I talk about governing documents. I'm talking about letters, patent, and bylaws. Policies include things like your code of conduct, your volunteer screening policy, your confidentiality policy. All of these things are great and important to have and may be affected by what's in your bylaws, but they're different in that they don't necessarily require board approval, they don't necessarily require member approval, and they're not necessarily about governance, they're more about your operations. So those are some of the key governing documents. In terms of the key people that we'll be talking about today, the key roles in your organization, we'll be talking about three generally. Number one, the members. And yes, all nonprofits must have members. Even if it's only one person or even if it's the same people as your board, both of those are allowed structures. But the point is you have to have at least one member. And who are the members? The members are the people who are called members in your bylaws or your constitution, whatever you call it. But the people, it's a term which is defined in your governing documents. If it's not defined in your governing documents, it will be by default the founders of the organization and then anybody that your first board appointed. If you do not use the term member, don't worry. The group of people who has governance powers like electing the directors or appointing the auditor, those are people who are essentially fulfilling the role of members. The second group we'll discuss, directors. These are the people elected by the members, or they may be appointed because of their office. That's referred to as an ex officio director. So for example, an executive director of an organization may be default, have a seat on the board as an ex officio director. They may be a non-voting member of the board. Even so, they're still a director. They're just a non-voting director. Directors are responsible for overseeing the management of the nonprofit. The third group of people we'll talk about today are officers. Officers are appointed for specific jobs like president, secretary, or treasurer. So whereas the board exercises its authority collectively through decision-making, officers have individual roles. So the president might be to oversee the organization as a whole, the secretary to make sure the records are in check, the treasurer to oversee the finances and the audits and so on.
So Benjamin, just before you move on, it's Heather.
Yes.
We did have a question in the chat box asking, we have objects in addition to bylaws. Where would these fall?
Sure. So objects tends to refer, it's another term in the law for purposes. So if what's contained in that document, that is your objects, is really the purposes of the organization, then it may be another document articulating the same thing as your letters patent. And in this case, it's the letters patent or the articles, which is the official statement of your purposes or your objects. On the other hand, if you just call it objects, but then it contains all kinds of governance rules about how your governance runs as an organization, then even though you call it objects, it has the legal role of bylaws. So again, it's not about what you call these documents. It's not about what you call the roles. You could call your directors anything, your members anything, your officers anything. It's not about the name. It's about what role are they fulfilling in the organization? What role is the document fulfilling?
And just two other questions that are sort of related. There's a question of, can directors serve as officers? And could a chair hold more than one officer role? For example, could they also be chair and the treasurer?
So the answer is yes to both. So directors can be officers, and in fact, you can make it a requirement of your bylaw in your bylaws, so you don't have to, that officers be directors, and the same person can hold more than one officer role. I will note that all of these I would consider substance questions. The objects question was more of a terminology question, but in general, I'll deal with substance questions at each of 3 stopping points.
Okay, great, thank you.
Okay, so you're obviously here, so you know the ONCA is important on some level, but what are some reasons you should actually care about the ONCA? Well, number one, it gives you an opportunity to revisit your governance. So there are the minimum things that ONCA kind of requires you to change maybe, but beyond that, it's an opportunity to open up your various governing documents, maybe blow off the dust if you haven't looked at them in a while, and ask yourself the question, do these rules still make sense for us? Good governance can add a lot of value to an organization, and so this is an opportunity to modernize with the Act beyond what it minimally requires. So a second reason you might want to get excited a bit about the ONCA is that some new things are possible. There are new flexibility in financial review area that might save you money. There are new flexibilities in terms of who can become a member that could lead to a more inclusive membership. There's new flexibility in terms of how to structure the board. We'll talk about all of this. And this might be a reason you want to take advantage of the ONCA sooner rather than later. And we'll discuss a bit more about the timelines and the pros and cons about doing it sooner or later. Number 3, your funders may ask you if you're compliant with the ONCA. For your funders, it may be a signal that you have your act together, so to speak, that you're on top of these sorts of things. It's not a very inspiring reason to care about the ONCA, but there you have it. And number 4, to avoid confusion later on. So as we'll discuss when we discuss the timeline, there's a 3-year transition period. So ONCA took effect October 19th, 2021. However, nonprofits do not have to comply with the ONCA if their governing documents say something different until October 19th, 2024. So in that 3-year period, so there are some exceptions to that general rule, but in that 3-year period, you basically don't have to worry. But what's going to happen at the end of the 3-year period is as follows. You're not going to cease to exist as an organization, but what will happen is your governing rules will automatically be considered to transition over to the ONCA. So what that means is that your documents won't contain what your actual rules are in some cases, and that's going to be very confusing. So to avoid that confusion, you may want to take an interest in the ONCA sometime in the next 3 years. Here are a couple of reasons not to worry about the ONCA. So number one, there are no ONCA police. It's nobody's job in the government to knock down your door and ask you, have you complied with your bylaws? The way the ONCA is set up is that it's your members who have the right to take you to court if they, see fit, and challenge you if you haven't complied with the ONCA. Now, it rarely happens, and most nonprofits can work it out with their members before it ever gets that far. So you don't need to worry about ONCA police. So that's one reason you don't need to be anxious about the ONCA. Number two, it's not a major overhaul. We're going to cover a number of changes today, but on the whole, it's nothing radically different from the rules you're used to. So you don't need to worry about an unrecognizable act or an act that is so different it will require you to fundamentally change your organization. Okay, so now we come to the first section of the presentation. What's new in the ONCA? I will discuss three kind of big differences, and these are probably the biggest aspects of the differences in the ONCA. Number one, public benefit corporations. It's a new concept in the ONCA. It didn't exist in the Ontario Corporations Act. Number two, the financial review standards have changed. And number three, the Ontario Business Registry, which is not the ONCA itself, but it's the technology that came online when the ONCA took effect. Okay, so public benefit corporations. Under Ontario Corporations Act, all nonprofits pretty much face the same set of rules. Under ONCA, by default, all the nonprofits face the same set of rules, but then one group faces some additional rules. So that raises the question, who fits into that group and what are the additional rules? So the group is called public benefit corporations, and the way a nonprofit is considered to be a public benefit corporation. So one person in the pre-session survey asked, why did I ask the question about your funding and whether you're a charity? So this is why, because I wanted to know how many of you are likely to be public benefit corporations. So the way an organization becomes a public benefit corporation is as follows. If you're a charitable corporation, so if you're a registered charity very often, then you're a public benefit corporation automatically. The other way to become a public benefit corporation is if you receive more than $10,000 in grants or financial assistance from the government. So again, this is not fee for service. It's not you have a contract with them and you're selling something. It's a grant or it's a financial assistance like a loan. And yes, COVID assistance funds would generally count towards this. Or more than $10,000 in gifts or donations from sources other than members, directors, officers, or employees. So membership dues do not count because they're from members. So that's another question we got in the pre-session survey. So generally speaking, what this is supposed to capture is if you get more than $10,000 from anybody who is not immediately connected with you, they're the public, either because they're the government, either federal, provincial, or municipal, or an agency like the Ontario Trillium Fund, or they're just individuals or organizations that aren't connected to you, like foundations or members of the public that you fundraise from, etc. So if you get more than $10,000 from any of those sources, the next year, you're a public benefit corporation, and that keeps on carrying over each year that you qualify. So what are the additional rules that public benefit corporations face? So number one, they face higher standards of financial review than other organizations, and I'll talk about that on the next slide. Number two, they're limited in who they can distribute their property to if they dissolve. So dissolving is when a corporation ceases to exist. It basically dies. So before it dies, it has to pay off all its creditors, so all the people it owes money to. If it has any money left or any property left, so that includes your assets and basically anything that you own. If you have anything left after you've paid off your creditors, the question is who gets those assets? And for a public benefit corporation, the organization is limited to either giving it to government, that means federal, provincial, or municipal government, or another public benefit corporation. And if the public benefit corporation is a public benefit corporation because it's a charity, then it can only give its assets to either government, federal, provincial, or municipal, or another charity that's a public benefit corporation. So that's what's called a dissolution clause. It's a line that says what you do with your property in the case of dissolution, and the default rule for public benefit corporations is you have to have a line in your articles saying you're limited in terms of who you can give your property to. The third additional rule that public benefit corporations face is that they can't have more than a third of their directors be employees. And this includes ex officio directors and non-voting directors. And so this is one of those moments where I say just because something is legal doesn't mean it's a good idea. ONCA doesn't say you have to have employees as directors. There may be accountability issues. All those directors that are employees, they still have to face all the same rules about conflict of interest. All the ONCA is saying is that for public benefit corporations in particular, they cannot have more than 1/3 of their directors be employees. Now, I will note here for charities, there are additional rules that make it very restrictive for employees to be allowed to be directors at all. So the financial review standards. The default is all nonprofits under ONCA need to get an audit. However, some nonprofits can pass what's called an extraordinary resolution and either get a review engagement instead of an audit, or waive the audit and not get any external financial review whatsoever. So that raises a few questions. One, what's an extraordinary resolution? Two, who can pass it? Three, what's the review engagement? So let's deal with those questions. An extraordinary resolution. An ordinary resolution is a motion passed at a meeting, a members meeting in this case. So you're like your AGM, an annual general meeting, that's supported by 51% of your members. That's an ordinary resolution. An extraordinary resolution is a motion passed at a members but supported by 80% or more of your members. So it's got a much higher level of support. You can also pass a written resolution outside of a meeting, but then it has to be supported by all of your voting members. So unless you have a very small membership, in practice, it's the 80% threshold at the meeting that will be relevant to most nonprofits. And you have to pass this each year that you want to waive an audit. Now, you can, if you waive the audit, depending on what your income level is that year, you can either get a review engagement or waive all external financial review altogether. So what's a review engagement? An audit, first I'll explain an audit, then I'll explain how review engagement is different. An audit is where a public accountant comes in, looks at your source documents, so that means your receipts and your invoices, that kind of thing, looks at your financial policies, so that means like your signing authorities and so on, looks at your financial statements that you prepared, and says, based on all this, I can provide reasonable assurance that your financial statements are a reliable reflection of your financial position. That's what an audit is. A review engagement, also known as a financial review, is where a public accountant comes in, looks at your source documents, looks at your financial policies, looks at your financial statements and says, okay, based on this, I can say your financial statements are plausible. Meaning to say, I didn't see anything in my review that would raise a red flag. So it's not the same level of assurance as an audit. It's faster. It may be more appropriate for an organization that is smaller and has more straightforward finances, but it doesn't provide the same level of assurance as an audit. So who can get what? So for organizations with annual revenue under $100,000, the rule hasn't changed. Under Ontario Corporations Act, you had to get an audit by default, but you could pass an extraordinary resolution and you could waive the audit and not get any external financial review. That's still true. For organizations with annual revenue between $100,000 and $500,000, if you're a public benefit corporation, you can pass an extraordinary resolution and waive the audit, but then you have to get a review engagement instead. You have to at least get a review engagement. If you're not a public benefit corporation, you don't even have to get the review engagement. So there's new flexibility. You can waive the audit altogether. Above 500,000, if you are a public benefit corporation, you have to get an audit. So nothing has changed from the Ontario Corporations Act to ONCA. In both cases, you have to get an audit. If you're not a public benefit corporation and your annual revenue is above $500,000, you can pass an extraordinary resolution, waive the audit, but then you do have to get a review engagement. So there's new flexibility. And in fact, under ONCA, if you're not a public benefit corporation, you never have to get an audit. Again, you may have to get an audit for other reasons. Your funders may expect it and so on. But under ONCA, you aren't required to get an audit. The last thing I'll talk about in this section is the Ontario Business Registry. So when ONCA came online, a new online system also came online. The benefits of this new registry is that it allows Ontario corporations to look themselves up, which isn't like the vanity of Googling yourself. It's more useful than that. You look yourself up and you learn what address does the government on record, who are the directors on record with the government, etc. So you can make sure that the government has the right information on record. They may not if you haven't kept up with your annual filings, which is why I asked that question in the pre-session survey, or they may not because there have been glitches. There has been data migration issues from the old system to the Ontario Business Registry, which is why it can be very useful for nonprofits to order a corporate profile from the Ontario Business Registry, just to make sure. It also allows you to make your annual filings online and to change your articles online, which may be something you need to do as part of the ONCA transition process. It shortens the response time to real time, so you don't have to necessarily wait a week or 2 weeks or so on to hear back from the government, as you might have before if you mailed things in. And it automatically shares certain information with the public guardian and trustee if you are a charity. Now, it doesn't share information with the Canada Revenue Agency. So I sometimes get the question, does this new system mean we don't have to file with the CRA? No, it does not. You still have to do all your filings with the CRA separately. So if you're a charity, that means your annual filing, your T3010, and so on. As I mentioned, there are glitches, so watch out. When we talk about the timeline, one of the disadvantages of doing transitioning to ONCA too early is that you have to put up with the glitches of the Ontario Business Registry. They're irritating, but if you have other compelling reasons to transition to the ONCA, the glitches are not the end of the world. So that brings me to the end of the first section. So I can now take some of the substantive questions.
Great. Okay, so I'm just going back to grab a couple of them because we've had a few. So Cynthia asks, does the $10,000 referred to the beginning have to be only a one-time grant for a nonprofit to be considered a PBC, or is it meant to be regular, such as yearly grants?
So it's a lump sum amount that you collect in that year. So whether if you get the money in that year, then it counts towards that year. And it's not just from one grant, it can be from a mix of different sources that count towards that ultimate sum of $10,000.
Okay, so I think that answers Karen's question, which was asking if that 10,000 comes from one source or is it an aggregate? It sounds like it's an aggregate. Okay, great. I'm just sliding down here. Question about the distribution of property. Can it distribute property during the normal course of business when there is no thought of dissolving?
Yes. I should note that a nonprofit is limited, right, in terms of its ability to distribute to its members. But the rule I stated earlier about it's limited only to distribute to government or to other public benefit corporations, that's only in the case of dissolution. So that rule doesn't affect how you're spending your money during the life of the organization.
Question here about so if the directors are all members and volunteers, does this still qualify as being employees for the purpose of being a public benefit corporation?
So no, employee is a like specific legal term under Ontario law. A volunteer and an employee are two different concepts for legal purposes. So the question is, are they being compensated for the work that they're doing on an ongoing basis? I'm not an employment lawyer, so I can't give you actually a very precise definition of what an employee is, but I can tell you that the Employment Standards Act of Ontario specifically carves out volunteers. So it's not volunteers.
Okay. For an extraordinary resolution, is it 80% of all members that are required or 80% of all members in attendance at the meeting that is required?
So my understanding is that it's in fact 80% of those voting at the meeting. So if somebody leaves the room during that vote, then that will affect what the 80% is for the purposes of that resolution.
Okay, and the final question, it looks like almost the final question. Are corporations incorporated under Ontario Corporations Act automatically registered in the Ontario Business Registry, or does the corporation need to register?
No, you're automatically registered. So I guess the answer is, well, I won't say yes or no. You are automatically registered in the Ontario Business Registry. So all your information is already up there. Again, there have been data migration issues, so it may not be entirely correct, but you are on the registry.
Okay, and then final question in this section looks like, if members make donations in addition to fees, would those considered to donation, would those be considered to donations for the purpose of the $10,000 threshold?
No, they would not, because it's only donations from people who are not your members, your officers, your directors, or your employees.
Okay, and final question just regarding dissolution. The question is, if an organization merges and you dissolve one organization to merge into another, does that dissolution clause of property distribution, how does that work under this?
It does kick in. So if that's how you're merging, then the dissolution clause would be triggered. So that's something to consider in terms of how you structure your merger or your amalgamation. And by the way, because a number of questions in the pre-session survey was, when do we get a lawyer involved in the ONCA transition process? Mergers and amalgamations, those are kind of complicated processes where there are a lot of moving parts that aren't intuitive, and there can be a lot of knock-on effects you don't realize you're having. This is a good example of a knock-on effect you don't realize you're having. And those are kind of situations where there may actually be added value to have a lawyer that knows what they're doing. Not all lawyers are familiar with nonprofit law, so it's important for the lawyer to be familiar with nonprofit law, but there can actually be added value of having a lawyer involved in a transaction like that.
Okay, those are questions for this section. Thank you.
Great. So the second section, what steps do nonprofits need to take to actually come into compliance with ONCA? So step one, figure out whether ONCA applies to you. So I'm reiterating a bit what I said at the beginning, but I'll provide a bit more detail now. ONCA applies to nonprofits incorporated under Ontario's Corporations Act and also most special acts. So if there was an act, if you're a very old organization, this was much more frequent, a century ago, and you're a very old organization, and so a special act was created just for you, or you're a special type of organization, like a conservation authority or an agricultural or horticultural organization, then there's a special act for your type of organization. ONCA layers on top of those acts, so they speak to each other in a lot of cases. The way ONCA is set up is that when ONCA and another act apply to you, ONCA, and there's a conflict between those two acts, ONCA yields to the other act, so the other act wins. So you never need to be worried about there being a conflict between two acts. Now, I get the question sometimes, I'm a charity, does ONCA apply to me? And the answer is, it applies to you if you are incorporated in Ontario under Ontario Corporations Act or some special act. So charitable status is something separate, especially if you're talking about registered charity. Your status under the Income Tax Act is separate from whether or not ONCA applies to you. Who does ONCA not apply to? It doesn't apply to federally incorporated nonprofits, so that means under the Canada Not-for-Profit Corporations Act. It doesn't apply to co-ops. It doesn't apply to business corporations that happen to be running on a nonprofit basis. So let's say you figured out ONCA applies to you, and now you're wondering, okay, when should I act? Should I act now? Should I wait? I hear there's this 3-year transition period. So what does that mean for the timing? So on October 19th, 2021, as I mentioned, ONCA took effect. Until October 18th, 2024, I mentioned that your letters patent, so your articles and your bylaws, or you may call it your constitution, or your objects maybe, continue to be valid, whether or not they comply with ONCA. However, if your governing documents are silent about a particular issue, then you are now looking to the ONCA for the answer, rather than before where you would have looked to the Ontario Corporations Act for the answer. So conflicts are allowed if it's in your governing documents before ONCA took effect, but if it's silent, the ONCA is the governing statute that applies to you during this 3-year transition period. What happens at the end of the 3-year transition period? So I mentioned that your letters patent and your bylaws are automatically changed to comply with the ONCA. What I'll add now is that there are a few key exceptions to this. Number one, under ONCA, nonprofits are required to specify the number of directors, so that's the number of seats they have on the board, in their articles. So somebody in the pre-session survey asked a question about this. Do you need to specify it in the articles? The answer is yes, ONCA requires specifying it in the articles. However, if you do not, because under Ontario Corporations Act, you would have put it in your bylaws. So if that information is in your bylaws and the 3-year pass and you haven't done anything, your board doesn't dissolve. It doesn't reduce to the minimum, which is 3. It continues to be valid as long as you don't make any other change to your articles. As soon as you make any change to your articles, all your rules, including these exceptions, all your rules are considered to automatically transition. So it basically ends the 3-year transition period for you. Similarly, member classes and voting rights. So if you have multiple types of members, this is called member classes in the ONCA. Under ONCA, if you have multiple types of members, you need to specify that in your articles. And you also need to say what the voting rights of each kind of member is. If you don't, it will automatically be considered that every type of member has 1 vote. If you have not done this by the end of the 3-year period, then the rule continues to be valid. You continue to maintain your membership structure as long as you didn't make any other changes to your articles. Again, if you make any other changes to your articles, the transition period is considered over for you and all your rules automatically transition. The third rule that can be valid even after the 3-year transition period is your dissolution clause. If you have a clause that says who your property is going to when you dissolve, and it is different from what ONCA requires from you, so if you're a public benefit corporation and you have a dissolution clause that says it goes to such and such organization, or it gets distributed to the members, or something else, right? Your dissolution clause continues to be valid as long as you don't make any changes to your articles. So, one of the big takeaways from this presentation is that as far as the timeline is concerned, be careful about making any changes to your articles before the 3-year transition period is up, or after the 3-year transition period, if you want to preserve these 3 exceptional rules. Because as soon as you make any one change to your articles, then it's going to bring you into the ONCA completely. So what's a practical example of this? Let's say you're applying for charitable status and the Canada Revenue Agency doesn't think your purposes are exclusively charitable, so they want you to change your purposes. That will require a change to your articles. So you say, okay, we'll just change our purposes and then we'll worry about transitioning to the ONCA next year. Unfortunately, by changing your purposes, you're having the effect of transitioning yourself to the ONCA and all your rules are automatically considered to transition. So that's one example of where you want to be mindful about making any changes to your articles. Okay, now pros and cons of the timing of the transition. I've heard ONCA transitions are estimated to be about 6 to 12 months. Thinking about why it might take you longer or shorter, variables include how easy is it for you to call a members meeting? Is that something you could call in a few weeks just to pass the bylaws you've approved by the board? Okay, well, that will speed up the process of the ONCA transition. How active are your members? Are they likely to send back the changes you've made with revisions? Are they likely to ask a lot of questions? Is there likely to be a lot of controversy about changes you've made? Okay, well, that will extend the period of time it will take you to transition to the ONCA. You know, how active is your board? How frequently does it meet? Does it have the capacity to review the bylaws? If not, do you have the funds to hire a lawyer, etc.? All these things will affect the how short or long it may take you to transition to the ONCA, but generally speaking, the estimate I've heard is 6 to 12 months. So with this 6 to 12 months timeline as a guide in mind, what are the pros and cons of starting earlier versus starting later? Because we do have this 3-year transition period. The advantage of starting sooner is some of the new rules that we've already discussed and that we'll soon discuss may be things you want to take advantage of, that you want to implement as soon as you can. The disadvantage is, as I mentioned, there are glitches with the Ontario Business Registry. Some of the advantages of transitioning later is it gives you more time to think about the changes you want to make, consult with your community, consult with your members, etc. The disadvantage, and of course there's no rush. The disadvantage is, you know, it may fall by the wayside, you may lose the momentum, etc. And you don't want to be in a situation where you're running up against a deadline. So the takeaway from all of this, because I can't give legal advice specific to you, is that in general, if you want to avoid confusion, think about transitioning sometime in the next 3 years. So you've decided you want to transition. What are your first steps? Where do you begin? The first kind of steps you can take are to get all the documents that you need together. I've done a lot of these sessions, and I've sent out a lot of the pre-session surveys, and I can tell you about, on average, about 1 in every 3 nonprofits reports either not knowing where their documents are or not having the not knowing that the annual filings are up to date, and so on. So don't worry if that's the boat you're in. It's a fairly common boat to be in, but it's a great idea to collect the documents just in general, not even for the ONCA. It's a good practice to know where your key documents are. So what are the key documents to gather? Number 1, your letters patent and supplementary letters patent. So we already talked about what the letters patent is. A supplementary letters patent is if you ever made changes in the past to your letters patent and then registered them with the government, as you were required to do, the government would send you back what's called a supplementary letters patent. It's kind of like an addendum. So in order to understand what your letters patent really is, you need both the letters patent and any supplementary letters patent so you can read them together. Number 2, your bylaws, your constitution, your objects, whatever you call them, the document with your governing rules in them, you need to know what those governing rules are to know if it's compliant with the ONCA, and also how to change those rules. That will usually be specified in the bylaws themselves. And I'll talk about, if it says nothing, what the default process is. So don't worry if your bylaws don't say anything. Number 3, your minute books. And I'm going to take a bit of a tangent to talk about minutes here, because I often get questions focused specifically on minutes. So what minutes do you need for ONCA and in general? Number 1, board meeting minutes. Number 2, board committee minutes. Number 3, member meeting minutes, both annual general meetings and special member meetings. Number 4, member committee meeting minutes. So often nonprofits know about the board meeting minutes and the member meeting minutes, but they don't necessarily know there is an obligation to keep board committee meeting minutes and member committee meeting minutes. So those are the types of minutes we're talking about. How many years back do you need to keep? ONCA doesn't set a specific number of years. So the implication of this is basically to keep all your minutes. In fact, for registered charities in particular, CRA has taken the policy position that you need to keep all your minutes, and even after you dissolve, you need to keep them for another 2 years. So you may be sweating, oh no, you know, we're missing all kinds of minutes. Our organization has been around for decades. I don't know where the minutes are. So just take a deep breath. It's really a risk assessment. In terms of what minutes do you really need, as I mentioned, ONCA police, there are no ONCA police, so there's nobody's knocking down your door who's asking you for the minutes. The Canada Revenue Agency may audit, and in which case the Income Tax Act requires at least 7 years of minutes, so of records. So the core 7 years, that's a requirement under the Income Tax Act, and Charities Directorate, if you're a registered charity, may be interested in minutes past the 7 years, in which case, as a general guide, again, not legal advice, but as a general guide, when you're asking yourself, what are the priority minutes for us to either reconstruct or to find, if something happened that year that may give rise to liability, so you purchased property, or there was an accident, or there was you were looking after vulnerable people, etc., right? Then those all increase your legal risk, and therefore they would make it more prudent for you to have minutes that might help you prove that the board was doing due diligence, there was effective oversight, they were acting reasonably, etc. So that's kind of a general guideline to how many years of minutes are theoretically required, but practically would be important from a risk assessment perspective to seek out. But again, if there really is a concern about liability, that might be a matter for legal advice. Another question I often get about minutes is, can we keep them virtually? One of the nice things about ONCA is that it explicitly says, yes, they can be kept virtually. In fact, they can even be kept on the cloud, as long as they are, and the cloud means, by the way, Google Drive or Dropbox, services like that. As long as your minutes and your records in general are accessible from your official headquarters, then it is fine to keep them virtually as far as ONCA is concerned. Another question I often get is in-camera minutes. Does ONCA allow them? What to do with them? How should we keep them, etc.? So ONCA does not address in-camera minutes directly. What it does say, however, is that for minutes in general, a nonprofit is only legally obligated to make board meeting minutes and board committee meeting minutes available to 3 types of people. 1, directors. So members of the board have a right to access board and committee meeting minutes. Number 2, an auditor or financial reviewer, if they deem it important for the work that they're doing, the review that they're doing. And number 3, a court-appointed investigator, which is a very rare occurrence. So in practice, you're really only thinking about other directors and auditors or financial reviewers. So what that means is that there is no obligation from ONCA to make those minutes available to the public or to members if they ask for them. You may have the practice of doing so, and that may be perfectly allowed under the ONCA. But if you want to keep something in camera, meaning you want to keep it private, you don't want it to be accessible to anyone other than the board, then ONCA creates space for that. So that was a bit of a tangent about minutes, just because a lot of common questions about that. Other documents that you may want to get together for the ONCA transition process. Special resolutions. So we talked about ordinary resolutions, we talked about extraordinary resolutions. In between the two are special resolutions. These are motions passed at members' meetings that require 2/3 support. Generally speaking, any changes you make to your articles would be special resolutions. So since you want to know what is supposed to be in your articles, having special resolutions are important. They also cover things like mergers and amalgamations, selling off major assets, etc. Directors and officers register. A register is just a fancy legal name for list. Nonprofits are required to keep 6 years worth of directors and officers information. So your current and former directors and officers going back 6 years. What information do you need to keep? Number 1, their names. Number 2, their start date. Number 3, their end date if they're a former director or officer. And number 4, their address. This is their physical address that they agreed to receive official documents at. Number 5, their email address, only if they agreed to receive documents electronically. So that's the directors and officers register. Nonprofits are also required to keep a members register. So this is a list of all of your members. The reason, so this is independently required, but practically speaking, the reason it's so important to have an up-to-date members register is members are the people who have the right to receive notice of annual general meetings. They're the people who have the right to vote for the board. They're the people who have the right to approve or reject any changes to the bylaws. So if somebody is entitled to vote who didn't get the notice because they weren't on the list, right, then they have rights under ONCA to basically come and say this was an invalid procedure. Right, so that's why it's so important. It's also important, this is a bit of editorializing, but it's also important from the perspective of being accountable to who your members are, to who your community is, to make sure that they're, you know, active and engaged. That starts with knowing the basic list of who they are so that you can contact them to inform them about their governance procedures, like meetings. So members registers, it's the same situation as director and officer registers. Nonprofits are required to keep 6 years worth of information, including the names of the members, the start date, the end date if they're a former member, their physical address that they agreed to receive official documents at, and their email address in the case that they agreed to receive electronic documents. Under ONCA, directors, in order for somebody to become a director, they need to consent in writing to be a director. So they do not become a director when they're elected a director. And the reason for this, I think, is as follows. If somebody became a director when they were elected a director, you could basically elect anybody, right? You could elect Sean Penn to be the director of your organization, and then 3 years later, contact Sean Penn and say, haha, you know, you've been liable this entire time, which would be hilarious to somebody like me. But the law doesn't allow it, unfortunately. In order for somebody to be officially a director under ONCA, there needs to be a written consent. So what does this consent have to include? It doesn't need to be a fancy legalistic document. It really just needs to include some basic information. I, so-and-so, agree to be director of such and such organization as of X date. And here's my address, just so you know exactly the individual we're talking about. And here's my signature. I often get the question, do you have a template? So we have some wording on our website, which I can show you at the end of this presentation. The Ontario Forms repository also contains a template that you can adapt. It is a template for the first directors of a nonprofit. They have not yet made available a template for directors in general, but it essentially it contains all the information I just discussed with you. I get the question, can a confidentiality form count? Can a code of conduct form count? Can a director nomination form count? In principle, all these forms could potentially count as long as they have that essential information documenting that the individual is consenting in writing to be a director of the organization. One thing that doesn't count that I've been asked about is minutes of the meeting where they're elected. The reason minutes are not valid as proof, unless they're signed by the individual with a statement saying I consent, is that minutes are general. They're recorded by somebody else. They're about the vote. They're not about the individual's consent. The last thing you might want to find out is your annual revenue, since this will inform what your financial review standards are and it may inform whether you're a public benefit corporation or not. Now, it's not only your own books and records that you want to get in order, it's also the government's. Nonprofits in general will want to make sure the government has the right address on file. And I should note here, it cannot be a PO box. It has to be a physical address. And I know that this is a problematic requirement for small and informal organizations where you don't have an official address, you just have everybody's home address, and you don't want anybody's home address to be made public, which it would be on the Ontario Business Registry. What I can say is that there are two general practices that small organizations use when they don't have a physical address. One is to use the office of a lawyer or an accountant, something like that, and list that as the address. Or two, to use some kind of shared space. In Toronto, we have the Center for Social Innovation. I'm not sure in Halton if there are shared office space services like that. But the point is here that you will need, in order to access the Ontario Business Registry, you will need the government to have the right address on file. Okay, so now we come to the actual process of updating your bylaws and articles. Disclaimer: if your bylaws say a different process from what I'm about to say, follow that. But keep in mind that no matter what your bylaws say, the voting members of your organization have the final say. They need to approve any changes to bylaws or articles. Now, there are two basic methods to how to approach changing bylaws and articles together. One is to start from scratch, just draft completely new bylaws. With articles, you can't just start from scratch. You have to amend existing articles. Method number two is to start with your existing bylaws and just make changes where necessary. One of the pre-session survey questions was, which one should we use? The answer is both work fine. There are pros and cons to both. The pro of starting from scratch is you start fresh, you have a clear document, it's a great renewal exercise for your governance as a whole. The con is that it generally takes longer. The pro of modifying is that it doesn't take as long. You can really limit it to what you need to change for ONCA. The con is that it can be somewhat patchwork and it can leave some more fundamental issues untouched. Either process that you use, the approval process, legally speaking, is the same. So the first stop is your board. Who does the actual drafting of the changes is up to you. You could have a lawyer draft them, and then that proposal is submitted to the board. You could have a committee of the board, or volunteers, or a mix of volunteers and the board, or a mix of employees in the board, and so on. Anybody on your side could draft them, and then that could then be submitted to a lawyer to review. So what are the pros and cons of each approach? The pro of giving it to a lawyer is they take care of it. It's one less thing for you to worry about. The con is it can cost money, but I think the more important con is that the lawyer isn't necessarily familiar with your organization, and they're certainly not as familiar as you are with your organization. So the rules that they draft may be legally sound, but they may not be suitable or realistic for what you'll actually put in practice. I've seen it happen time and time again where perfectly well-drafted bylaws were completely ignored. Compliance, that's useless. That doesn't help anybody. In fact, it's almost worse to have bylaws that you don't follow than it is to have no bylaws at all, because the bylaws are things you adopted and then took on to follow yourself. So that's the con of having the lawyer do it from the start and not have you be heavily involved. The pro of having somebody on your board or a committee or so on do it is that it can be an educational process for those in your organization. It can be, they can generate rules that they're actually going to have to live with, so it'll better reflect what is realistic, and then you'll more likely to put it into practice. It's a part of getting buy-in in the organization for the bylaws. The con is that you're not experts. You have other things to worry about. Generally speaking, people do not join an organization because they're excited about the bylaws. So it can be demotivating for volunteers to be dragged down in governance. And it can be more time consuming. It can take longer. So there are pros and cons to both approaches. What I would say in general is that the involvement of a lawyer is never an all or nothing matter. Whether the lawyer takes a crack at it first or you take a crack at it first, both parties can be heavily involved, and there are always steps you can take to reduce costs by doing at least some of the work yourself. And there's no one size fits all, different levels of involvement from a lawyer or not, ranging from no involvement at all to complete charge of the situation will be more or less appropriate for different organizations. at the board, once the changes are proposed to the board can approve them according to whatever the bylaws say is the usual course of action for approving things. So it could be a simple majority. If your bylaws say nothing, it would be a simple majority. And in terms of when the changes to your bylaws are effective, if you say nothing, they're effective as of the date the board approves. Your board can also say they're effective as of the date that the members approve them. So just be mindful of the timing in that as a general kind of thing to be mindful of. Once the board approves them, they're only effective up until the date that the members approve them. The members' approval is what's required to make changes permanent. So that means you need a valid members meeting in order to make your changes permanent. So what do you need for a valid members meeting? So number one, you need to give notice to the voting members. The notice must provide sufficient detail for members to make up their mind about what they're being asked to vote on. So that might mean making the proposed new bylaws available to them. It may mean a track changes document, a compare and contrast. There are different ways, but the spirit of the matter is they need to have enough detail to make an informed decision. Notice needs to go out at least 10 days in advance of the members' meeting. Your bylaws may say how long in advance, in which case follow that. If your bylaws don't say anything, ONCA says it needs to be between 10 days and no earlier than 50 days before the members' meeting. The members' meeting has to have a quorum of members. If your bylaws say nothing about a quorum, and a quorum, by the way, is the minimum number of members required for official business to be transacted. If your bylaws say nothing, the default quorum is 51% of members. So a quorum is in attendance at the meeting, and then comes the approval or rejection or amendment at the meeting itself. For bylaw changes, by default, if your bylaws don't say anything, by default, it requires an ordinary resolution. So remember, that means 51% member approval. For bylaw changes, for changes to articles, it requires a 2/3 approval. Remember, a special resolution, 2/3 approval of the members. Once you've got the members' approval, then you've got all the internal approvals that you need. Now it comes time to file with the government. So what needs to be filed with the government? For nonprofits that are not charities, only the articles need to be filed with the government of Ontario, as far as ONCA is concerned. And I'll talk about how to do that in a couple of slides. For registered charities, both the bylaws and the changes to the articles need to be filed with the Canada Revenue Agency, and there's a simple online form to do that, which you can just Google, change bylaws, charities, CRA, something like that. It should give you the document you need. The public guardian and trustee has said they don't need to be involved in charities transitioning to the ONCA unless the charity is planning on changing its purposes. Now, you may wonder, at what point should you be getting the Canada Revenue Agency involved if you're a registered charity? And the answer is, generally speaking, if you're making changes that you think might affect your charitable status, so you're planning on changing your purposes, or you're planning on changing, I don't know, some property rights or something like that, then before you go to the trouble of getting it approved by the board and getting it approved by the members, it may be prudent to inform the CRA of what you're thinking to get their feedback. So, but every case is different, and this may be something to consult a lawyer about. Okay, so that's the how of changing to your bylaws and articles. What might you want to change? Here are 5 examples, not comprehensive, but 5 examples of things you might need to change. Number 1, under Ontario Corporations Act, nonprofits were required to appoint a president and a secretary. That's no longer required under ONCA, but what is required is appointing a chair. This could be the same title, the same role as president, but now you're just changing the title, or it could be a totally new role. That's up to you. The chair is the only officer required to be a director of the organization. This person needs to be a director. The second option that you might want to change is that now under ONCA, corporations can be members of your organization. Why might a nonprofit want corporations to be able to be members of their organization? It could be a fundraising strategy. It could be a way to build accountability in the community to other public benefit organizations, but it's an option now. It needs to be explicitly stated in your bylaws that corporations can be members. If you have multiple member classes, that means you have different types of members. In your bylaws, it must specify how to join the class, how membership in the class ends, how to withdraw or transfer between classes. Under Ontario Corporations Act, members holding 10% of the votes were able to demand that the board call a members meeting. Under ONCA, by default, members holding 10% of the votes have that right. You can specify in your bylaws a lower threshold. So you can say, as little as 1% have that right. The pro is that it may empower your members, make it easier for them to be active in your governance. The con is that it may be disruptive if you think that you have members that would abuse this right. The final example I'll give is that voting members of your organization do not by default have the right to proxy voting. Proxy voting is where a member appoints somebody else to attend a member's meeting on their behalf and vote on their behalf. By default, members of your organization do not have this right. So if you want them to have this right, it needs to be specified in the bylaws. And now we come to the final step, updating and filing your articles. So what might you want to change in your articles? So number one, your purposes. Now, this isn't required by ONCA that you change your purposes. However, while you're engaged in this general investigation of your governing documents, you may find that your purposes are completely out of date. They don't reflect your activities anymore. You've pivoted, you've added activities and so on. Especially for charities, it's very important that the purposes and the activities reflect one another. So you may realize that you need to update your purposes. Updating purposes for a charity is one area where it may be prudent to consult a lawyer knowledgeable in charity law. Number two, the number of directors, as I mentioned earlier, under ONCA is required to be specified in the articles. There is also a new option. You can specify a range of directors. Under Ontario Corporations Act, you could only specify a fixed number. Under ONCA, you can specify a range. Why might you want to do this? Well, it basically gives you flexibility because you have, let's say, 5 to 10 is what's said in your articles. And then each year the board has the option to pass a resolution saying this year it will be 5, this year will be 8, this year it will be 9, which let's say an emergency happens, as they want to do, and you need more capacity on the board. So this is easier than going to the members to say, okay, we need to expand the board. We need to file a change to the articles. There are some other things you might want to change, such as membership classes and voting rights. I'll just note generally, because one of the pre-session survey respondents asked this question, anything that was allowed under Ontario Corporations Act is still allowed as far as membership structures go. So there are no new restrictions. I can't comment on specific membership structures if they're valid. Okay, so what do you need to file the articles? Once you have them, how do you file them with the government? So there are 3 basic ways to do it. 1, you can do it by mail. 2, you can do it through a third party, and they're specified on the Ontario Business Registry website who those third party companies are. And 3, you could do it online through the Ontario Business Registry. To access the Ontario Business Registry, you need 3 things. Number 1, a Service Ontario account. Number 2, a one key. And number 3, a company key. The Service Ontario account and the one key are fairly straightforward to set up. If you receive any transfer payments from the government of Ontario, it'll be the same account that you use. You can create them entirely online. The company key is a bit more complicated. You go to the Ontario Business Registry website, you scroll down a bit, you click on Order Company Key, you type in the information, and what will happen is the company key will be sent to the address that the government has on file. This is why it's so important that the nonprofit makes sure that the government has the right address on file, because otherwise the company key will be sent to the wrong address. I have heard it can take upwards of 3 to 5 weeks to get the company key, so some patience is required. But if you've been waiting a long time, one thing you can do is check that they have the right address on file. So that brings me to the end of this section. So I can take questions now. I see we're running short on time, and then I'll briefly, in the last minute, I'll tell you about some of the resources we have.
Okay, so we do have a number of questions. So there's a question, sorry, just going down here. Hang on. We've got a lot of them in here. Here we go. So in between, so the question is, can we specify which members have voting rights in our bylaws or instead of in our articles?
Under ONCA, no. The voting rights need to be specified in the articles.
Okay.
Now, during the transition period, they can be in the bylaws. That's what I mentioned. Even at the end of the 3 years, if you've changed nothing else, they can continue to be specified in the bylaws. But once you've transitioned to the ONCA, they need to be specified in the articles.
Okay. Question was, if we made changes to our bylaws last year, how does this affect us going forward? Would there be any issues in terms of the ONCA if bylaws changes were made last year?
So if you made the changes before the ONCA took effect, then you couldn't have made changes to your articles that were ONCA compliant. So in general, that's something that may still need to be done. So that's one aspect of it. Your bylaws, depending, I don't know if you did it with advice or so on, but something lawyers were recommending before ONCA took effect was to make bylaws as compliant as possible with the ONCA under the Ontario Corporations Act. So they may not have done the full transition process. So, but I can't advise. All I can say is that changes to your articles to be compliant with the ONCA couldn't necessarily have been made prior to the ONCA, because some things are only allowed under ONCA that weren't allowed under Ontario Corporations Act.
Okay, so I've got a couple of questions here around with concerns around the glitches you've mentioned in the registry. So it sounds like the best way to start resolving those is to make sure that the government has a correct address on file. Mm-hmm. And then to, once you know that's correct, going ahead and getting those registration documents so that you can double check everything and make sure that they've got the board director information and everything is up to date and it's correct.
Yeah, that's correct. And unfortunately, what that requires is going through the third party first, because both the mail. So first ordering a corporate profile to see what the information is, and you don't need a company key to do that. Anybody can order it. Unfortunately, there's a fee. But then to make the change to the address, if the government has the wrong information, that requires going through a third party provider.
Question is, can members be defined in the bylaws as the board of directors exclusively?
Yes, however, as far as it goes defining them in the bylaws, if you have one class of members, some lawyers say even then it needs to be in the articles, but in general, it seems like if you only have one class of members, it can be in the bylaws. But if you have multiple types of members, that would go in the articles. But yes, you can have a membership structure where only the directors are the members.
Is a dissolution clause required for a small non-profit, non-charitable NPO with equipment as our only property?
So the dissolution clause applies to all property, so not just money, but also assets such as equipment. Whether a dissolution clause is required by ONCA, it depends if you're a public benefit corporation or not. In general, is it required? It's not required. It may be prudent to have one so you don't have the fight when the organization is falling apart and people are looking at the property that they want, but I can't give legal advice. But it's not required under ONCA.
A question here about the consent for board directors. So would an application to join the board with all those elements serve as documentation of their willingness to be elected or appointed?
It may. Again, the essential elements is I consent to be director of the organization, because it depends how the application is worded, right? It might just be an expression of interest. It may not be signed. It may not have their address on it, right? So the name of the document isn't as important as whether it has those essential elements or not. What ONCA says is that the consent needs to be obtained when they're elected or before they're elected. So in principle, a nomination form could.
Okay. A couple of questions here around quorum requirements at meetings. So what happens if you cannot get 51% of your members attending your meetings?
So for nonprofits that are having trouble reaching their quorum, one strategy, and again, I can't advise whether this is a good idea in any given case. One strategy is that the directors can change the quorum temporarily, right? Because they can make changes to the bylaws unless your bylaws say the directors can't, which is possible. The director can make temporary changes to the bylaws to lower the quorum. And then that needs to be approved at the meeting. Now, if that sounds fishy, it's because it can be if directors are doing that. So it may not be a great precedent to set, but again, there are pros and cons, and I can't advise in any given case. The other thing is that if a nonprofit is having trouble meeting the quorum, it may want to ask why, how it could better engage the members, can it offer dinner, that kind of thing.
Okay. What needs to be put into articles or bylaws, if anything, if the only members are the board members?
So
the members of your organization are your board members.
Yep.
So I'm assuming that the quorum for a board meeting then would be the same quorum for a members meeting, since there's essentially the same group.
So not necessarily. You could have different quorums kind of meeting. So despite the fact that it's the same people, they wear different hats, and you can specify, if you choose to, specify different rules. In terms of what is required to be put in the articles, as I mentioned, some lawyers think that it's basically the same thing, whether you have one type of or multiple types of members. You have to say what they are, what the voting rights are, and then in the bylaws you have to say how to join, how to leave, etc. Some say you don't. If you have multiple types of members, if you only have one type of member, you just need to say in the bylaws what they are, their voting rights, and how to join, and so on. So it's an area that has yet to be determined.
Okay. I'm just looking at the time here. We have a lot of other questions. So for everyone on the call, what I'm going to do is I'll be saving the chat and I'll be sending these questions directly to Benjamin, asking him to provide some general responses, which we will then send out at a later time, hopefully before the end of next week, based on his schedule and things like that. But we will get to all those questions, but we're going to continue on with the presentation just so we are on time. Thank you.
Great. So just very quickly, I'll highlight some of the things that are available on the CLEO's website. There's a lawyer directory, so we don't vet the lawyers, but they've shown that nonprofits are some part of their legal practice. We have a glossary of terms that will help you understand the terminology of the ONCA as you read through it. CLEO's bylaw builder, so this will help you draft bylaws from scratch. A sample bylaws with options. This is a more paper-based way to help you draft bylaws from scratch. CLEO's bylaw builder is a much more interactive interview process, and it generates a specially designed set of bylaws. So there are visual elements that make it easier to navigate the bylaws and so on. CLEO's guide to how to adjust existing bylaws gives you a side-by-side comparison of what may be in your current bylaws and how the ONCA affects them. So if you're adjusting your existing bylaws, it can be a useful tool. And finally, you can email me with questions. Here are some questions that you asked that I might have gotten to if I had time at the end, but I'm just going to flag at the bottom of the slide. Here is my email address, and here is the URL. I will definitely get to the questions in the chat, but feel free to send me other questions as well. Thank you so much.
Wonderful. Thank you. So yes, everyone, thank you so much for being here today. I just want to be respectful of everyone's time. You will be receiving the recording. We will have some of the other resources that were mentioned. We will make sure that you'll get the link to CLEO's website and also the Ontario Not-for-Profit Network's website, which also has some information. And there were a couple of resources that Benjamin mentioned. That will be sent out later on today along with an evaluation form. The recording will come, probably we'll upload it to the Volunteer Halton YouTube channel so that you will have access to it and can review it, because there was a lot of information shared today, which if you were like me, you're probably scrambling and writing down all kinds of notes. And then the questions that I will make sure that Benjamin gets to respond, we'll compile that into a single response email to send out to everybody. But as he's mentioned, you are also very welcome to send him your questions directly. So Benjamin, thank you so much on behalf of everyone here today for this great presentation, this great information. I can see the comments in the chat about everyone's feedback, and they're very informative. We appreciate you taking the time today. Thank you everyone for being here, and watch your emails for that information. Thanks everyone.